Hello, this is regarding the Constitution, Indian Constitution, and mainly the federal features of Indian Constitution. If we see the Indian Constitution, as we have seen last lecture, it was the quasi-federal in nature. Some features are very much very much federal in nature. Some features are very much unitary in nature. So that's why if we analyze the Indian Constitution, we will find some features of the federal Constitution very much similar to the federal constitution. Some features on the modification of the federal principles. Basically, it's a federal in nature, but some modifications have been made, and some features are very much distinctive in nature. It is only found in Indian constitution. Nowhere we will find such type of provisions. So some are very much similar to federal constitution. Some are modified form of the federal constitution, and some of the distinctive character are only available in Indian constitution. So this is all about the Indian Constitution, all the provisions of the Indian Constitution nature. So that's it. You will find the federal. So first, if we go to the Indian Constitution, before entering Indian Constitution, we have to understand the forms of Constitution is the federal principle and the quasi-federal. Those combinations you will find there. And then what is federal constitution? Federal constitution is a vast subject. Federalism itself is a vast subject. There is a book written by D.D. Basu, that is Comparative Federalism. This is means masterpiece, a very much famous book where we will be able to understand what are the various forms of the federalism, various types of federalism, the government of federal government. But some chief characteristics of the federal system are these 5 features. That is distribution of power, supremacy of constitution, written constitution, rigidity, and authority of courts. What does it mean? The first, distribution of power. The basic feature of the federal constitution, basic characteristic of the federal system is that there must be 2 sets of government. One is the central government, other is the local government or the federal government. One must means or the state government. So one is the national government or union government, and other is the state government. Now there must be a distribution of powers between these 2 sets of government. Now, what are those powers? The 3 powers we have already seen from the French Revolution, from the separation of power of the Montesquieu. We have seen there are 3 types of state powers are there. One is the legislative power, the making the law. Second is the executive power, the execution of the law. And third is the judicial power, the interpretation of law. These 3 types of powers are distributed among the 2 sets of government. This is the one of the characteristics of the federal government or federal system. Second thing is the supremacy of the constitution. Here neither state government nor the central government, no one is supreme. Who is supreme? Even the executive, the legislature, or the judiciary. None of them are supreme. Constitution of supreme. So constitution itself has demarcated the area between the center and the state government, as well as demarcated the area of the function of the executive, judiciary, and the legislature. And that constitution is a written constitution. Without the written constitution, this one of the feature of the federal constitution is the written constitution, because through this writing, these powers among the state and the center have been distributed. This is the distribution of power, a written constitution. And rigidity. Rigidity means provisions are very much rigid. It's very difficult to change, very difficult to amendment. So in the federal constitution, rigidity is another important feature. Here to change amend the constitution is very much tough process. And 5th feature is the authority of courts. If there is any dispute, if there is any kind of ambiguity, if there is any kind of interpretation of provision of the constitution, then court is the authority of court. Court has the authority to interpret the provision and to interpret the constitution of provision. If there is any kind of dispute, if any kind of dispute arise, or if there is any kind of ambiguity in the constitutional provision, it should be provided, it should be removed, the difficulties should be removed by the courts. So court has the authority over these government and authority about the interpretation of the constitution. So these five features are the main feature of the federal system or the federal constitution. Distribution of the power, supremacy of the constitution, written constitution, rigidity and authority of courts. If we see, the Indian constitution has all of these characteristics. Now, modification in application of federal principles. These federal principles have somehow modified. When we go to the Indian constitution, we'll see that Article 3 is telling the parliament can alter and diminish, increase the area boundary of any state and can alter the name of the state. State is the exclusive jurisdiction of the state. But Union Parliament has the power. Any area of the state can be changed, can be altered. Even name of the state can be changed and can be altered by the Parliament, Union Parliament, which is against the chief characteristics of the federal system. But here it is available. In Indian Constitution, it is given power to the Parliament. So that's why it is the modification of applicable federal principle. Another important feature, you will see governor of states are appointed to president and hold the office during his pleasure and answerable to him. This is Article 155, 156, 163, where governors, every state has one governor. Actually, this governor is being appointed by the president. The state government, governor of the state, but being appointed by the president. Not only that, he may be removed by the president. He is holding the office, pleasure of the president. Means he is the representative of the president. President is the union feature, but he is representing the union in the state level. So this is the modification of the federal principles. And again, you will find some other modifications. Suppose laws passed by the state legislature may be reserved by the consideration of the president or previous sanction of the president is needed before the move to the state legislatures. Some laws which have been passed by the state assembly, state legislative assembly, in spite of that, the consent of the president is needed. Or suppose power of the parliament to legislate some state list. We have the three lists. In the federal government, all the powers, as we have seen, the distribution of power, to power where parliament can make the law, where state parliament can make the law, where central parliament can make the law, that powers have been given in the schedule 7 of the Indian. That area means that topic, subjects of the legislative competence over the subjects are distributed among the state and center in the Schedule 7, which has the three list. Schedule 7 has the three list: state list, union list, state list, and the concurrent list. Where state has the power, but state can make the law on the state list. But if you see the 249, where Parliament has given the power to make the law on any topic, on any matter which is the state list for the national interest. If Parliament thinks it is needed for the national interest, Parliament can interfere in the state subject also. Union government, if you see, union government is empowered to issue the administrative direction of the state. Some provisions are there, that is Article 256, 257, where union government is empowered to keep the administrative direction, respective executive action, that is in the state matter, to the state also. Now, another some principles you will find that during the emergency is a peculiar situation. If you see the classic federal constitutions, suppose US Constitution or suppose Canadian Constitution, you will not find such type of provision, because those constitutions were made very early. They were not aware, they could not foresee the emergency provisions. Actually, those constitutions which are made mainly after the Second World War, those constitutions were framed where you will find the provision of the modern constitution. You will find the provision of the emergency. So during the emergency period, Union Parliament can control the legislative, executive, and revenue power of the state. This is another the feature which is very much against the federal principles of any state. But in Indian Constitution, you will find that Article 352, 353, and 354, which are related to the emergency provision. Even President can proclaim emergency in case of failure of constitutional machinery in the state in Article 356, where President can call for an emergency provision. So emergency provision, you will see President of India, which is the India Union government, has the power to call for the emergency for the state if there is a failure in the state machinery or constitutional machinery. And again, you will find Article 360, where all the monies of the state legislations and salaries and allowances of public servants of the state will be under control of the center during the financial emergency. Another emergency is there. One is the same. When we will study the emergency chapter, we will see Indian Constitution has the three types of emergency: national emergency, state emergency, and the financial emergency. Suppose if financial emergency is imposed, suppose financial emergency is going on that time, the states, in a particular state, or the all states, suppose financial emergency has been proclaimed. During these period, states, legislatures, their salary, their allowance, their public servant, their salaries, their allowance inside the states will be governed by the center, and center has a direct control. This is very much against the principles of basic principles of the federal structure. Apart from that, some distinctive feature, as beginning we have seen, some is a modified form of the federal provision, and some distinctive features of the Indian federalism, which we will not found. What are those? Suppose no dual citizenship. As we have seen, there are two sets of governments out there in the federal constitution. One is a central government, one is a state government. So generally, you will find the same step of federal country, you will find there are two types of citizens. One is state citizenship, another is the national citizenship. You are the first the citizen of the state, and you are next you are the citizen of the country. India does not have such type of dual citizenship. Only if you are Indian, you're the Indian, you're the only one citizenship. You can decide, you can move, you have no need of state citizenship. This is distinctive feature. The federal constitution, you will find the two types of constitution. Standard, the classic federal constitution, there are dual citizenship is there. Or single constituent authority. There's also, you will see the laws are being framed by a single constitution, single parliament is there. Or in the time of the judiciary, you will see the only single judiciary is there. The constituent authority is also single. And as we have discussed during the emergency, state emergency, financial emergency, central emergency, on that time constitution become unitary in nature. This is where union government or the central government is taking all the powers, legislative power, legislative, financial power. Another term is coming here, cooperative federalism, not the competitive federalism. Here, center and states are not the rival to each other, or both the states are not, two sets of states, and they are not the rival of each other. They will develop themselves through the comparative or cooperative manner, but not the competitive manner. They are not the competitor. So this is another feature. This is the cooperative federalism. Both are helpful. And another distinctive feature, you will see that single judiciary, as we have seen already. Single judiciary, here is no the state judiciary, or there is no federal court, or there is the state court. If you see the USA, there are two sets of courts are there, two sets of police are there, federal police or the US police. But if you see India, there is no such type of two sets of, means police are there, but there is no judiciary is there. There is not the state judiciary is there, and high court things are totally applicable before the Supreme Court. The Supreme Court, Supreme Court, now all the high courts are coming under the purview of the Supreme Court. So against the decision of the any lower judiciary, you can go to the High Court, and against the decision of the High Court, you can go to the Supreme Court. There is no parallel two sets of judiciary. That's just judiciary is single. Apart from that, you will see some features, all India services. Those services are there. There is no two sets of services are there. There's all India services. These all India services, suppose you are IS officer, IPS officers, or Indian Revenue Service officers, Indian Forest Service, those service officers, all India services, those officers can work throughout the country, any state, or they can go to any state, and they can go work for the union government also, to Indian government, central government, as a state government. So all India services are being framed, which very much against the feature of the federal constitution. Apart from that, some basic laws, the civil laws or criminal laws, those are very much common. There is no such segregation. Those are applicable all the citizens throughout the India. Now, if you see distinctive feature, another distinctive feature, legislative subject, long concurrent list. Apart from the state list and the central, there is a concurrent list where both center and state both can make the law. Parliamentary control over the legislative action of national importance, as we have seen during emergency or international agreement, Parliament has the control over the legislative action. So Parliament has the also supremacy here in the case of emergency, in the case of national interest, or any kind of international agreement also. And some situation where state has given the consent to Parliament to make the law. In those cases, Parliament has the legislative activity. And during the amendment, there is a chapter in the Constitution. We have to study in detail. We will see also there are three types of amendments, and those amendments time you will see this is very flexible in nature. We have seen that in federal constitution one of the important provision is that rigidity. This is very rigid. Rigid means it's very difficult to change, it's very difficult to amend. But if you see the Indian constitution, there are unique blend of rigidity and flexibility. Some provisions are very much flexible to amend. But that's why in that sense, it is the amendment of the constitution is another distinct feature which is unique mix of the rigidity and flexibility.